grandmother accused of child endangering in Ohio's so-called House of Horrors case has some big requests, and her attorney is telling us exactly what happened the day Christina Siders and her family were arrested and taken to jail.
On Monday, July 28th, at 31 minutes past 11 in the morning, an attorney in Ohio filed 2 motions on behalf of a 67-year-old grandmother named Christina Siders. The first motion asked the court to let her out of jail. The second asked the court a stranger question, whether she is even mentally capable of being put on trial at all. Her husband's lawyers asked it first. Then her son's lawyer asked it. Now hers has asked it too. 3 of the 4 adults accused of keeping 16 children in a single room are no longer only saying they're not guilty. Each of them, through a different lawyer, is now raising a different question entirely. Not did we do this, but are we even well enough to be tried for it? That is the turn this case has taken. 16 children were carried out of that house 4 weeks ago. The man who called it the worst scene of his career is still waiting to bring charges to a grand jury. And in the meantime, 3 of the 4 people accused of putting those children there have quietly lined up at the same door, the one marked not competent to proceed. Walk through it, and a trial doesn't get delayed. It may never happen at all. Before we go further, this case involves the abuse and neglect of children. I won't show them, name them, or describe their conditions for shock. But if this is heavy for you, take care of yourself while watching. If you're new here, this is Quiet Record. Verified reporting, named experts, nothing invented. Subscribe if that's what you want. Tell me in the comments where you're watching from, and to everyone who's followed this case across 5 episodes now, you are the reason it's still being asked about after the cameras thinned out. Thank you, because tonight is not about what happened inside that house. We have spent 5 episodes on that. Tonight is about a colder, stranger question that the last 2 weeks have forced onto the table. What happens to a case when the people accused may never be able to stand trial for it? Let's start with the word itself, because everything in this episode turns on it, and almost everyone uses it wrong. Competency. In the law, competency is not about whether someone was insane when a crime happened. It is not a defense. It is not an excuse. It is a question about right now, about the defendant's mental state on the day they are supposed to sit in a courtroom. Ohio law presumes every adult is competent, but that presumption can be challenged, and it can be challenged by the defense, by the prosecution, or by the judge. The test has 2 prongs, and a forensic psychiatrist named Dr. Daniel Bober laid them out precisely on Law and Crime this week. First, does the defendant understand the nature and the objectives of the proceedings against them? Do they understand what a judge is, what a charge is, what is happening in that room? Second, are they able to assist in their own defense? Can they work with their lawyer, understand the advice, make decisions about their case? Fail either prong, Bober said, and a person is found incompetent. Not innocent, not guilty, incompetent. The case simply cannot move. And here is the distinction that trips up almost every comment section discussing this case. Competency is about the present. Sanity is about the past. A sanity evaluation, the not guilty by reason of insanity question, asks what the person's mental state was at the moment of the alleged crime. A competency evaluation asks only whether today they can meaningfully participate in their own trial. A person can be perfectly sane at the time of an offense and still be incompetent to stand trial years later. A person can be competent to stand trial and still mount an insanity defense about the past. They are 2 different questions, aimed at 2 different points in time, and this case now has both of them running at once, across multiple defendants. Keep that split in your head, because it is the key that unlocks everything the defense is doing. And understand who actually answers the question, because it is not the judge and it is not the lawyers. When competency is raised, the court appoints a forensic examiner, a psychologist or psychiatrist trained specifically in this kind of evaluation. Bober, who performs these assessments himself, described what one involves. It is not a conversation about guilt. The examiner never asks the defendant to relive the alleged crime. Instead, they probe the machinery of understanding. Does this person know what a judge does? What a plea is? What the word guilty would mean for them? Can they track a conversation, hold information, weigh a decision their lawyer puts in front of them? The examiner is measuring a mind's capacity to participate. Nothing more, nothing less. And then they write a report, and that report goes to the judge, who makes the final call. The evaluation informs the decision. It does not make it. There is one more feature of competency that almost nobody outside the system understands, and it matters intensely in this case. Competency is not permanent. A person can be competent today and incompetent in 6 months, or the reverse. It tracks the mind's actual state over time, which means these evaluations are snapshots. And for defendants whose conditions may be changing, whether improving with treatment or declining with age, the question of competency may have to be asked more than once before this case ever reaches a jury. Now, the 3 motions, because they did not arrive together, and the order in which they came tells a story. The first was Gary Siders Sr., the 73-year-old grandfather. We have covered his thread since the beginning: the wheelchair, the confusion at his first hearing, the attorney who said he could not discuss the legal process with any sophistication, the dementia comparison. On July 9th, a judge ordered a competency evaluation for him. That one surprised no one. A visibly frail elderly man who appeared not to understand his own arraignment is the textbook case for a competency question. If anyone in this family was going to raise it, it was going to be him. The second motion is the one that should stop you, and it is the reason this episode exists. On Friday, July 24th, the attorney for Gary Siders Jr., the 36-year-old father, R. Lee Roberts, filed a motion raising competency for his client, and he filed it in an unusual way. He asked the court for permission to file the actual competency motion under seal, meaning the public would not be able to read it. His stated reason: the documents contain, in his words, highly sensitive mental health information directly reflecting the defendant's psychiatric condition, the public disclosure of which would unnecessarily invade the defendant's privacy. He was careful to say he was not trying to seal the whole case, only the portions dealing with his client's mental health and the request for a psychiatric examination. Now hold that against what we actually saw of Gary Jr. This is the defendant who, on the booking video, walked in on his own, answered the corrections officers, moved around just fine. At his arraignment, he understood enough to ask to speak with a lawyer before entering a plea, which is itself a signal of a functioning mind. He was, by every visible measure, the most physically and mentally capable of the 4 adults in that jail. And he is the one whose lawyer wants his mental health evaluations sealed from public view. I want to be careful and fair here, because this is exactly the kind of moment where speculation runs ahead of fact. Raising competency is not an admission of anything. It is a routine, legitimate tool, and a defense attorney has an ethical obligation to raise it if he has any reason to believe his client cannot understand the proceedings or assist in his defense. Dr. Bober said plainly that this kind of motion does not surprise him at all in a case like this. It may be entirely sincere. It may reflect something a jailhouse conversation revealed that the booking camera never could. But it is also true, and Bober was candid about this, that competency can be used strategically, that a defense may raise it to slow a case down, to buy time, to delay a reckoning. Both things can be true at once. The concern can be genuine, and the timing can be useful. What we can say for certain is narrow and factual. The most functional appearing defendant in this case is now the one seeking to keep his psychiatric evaluation out of public view. What that means, only the sealed pages know. And then came the third motion, the one from this week, the one almost nobody saw coming. Christina Siders, the grandmother, 67 years old. On Monday, her attorney, an assistant state public defender, filed for a competency evaluation on her behalf, stating that counsel has reason to believe she is unable to fully comprehend the proceedings in the court and unable to assist counsel in the preparation and defense of her case. The same 2 prongs. The same statute, the third member of this family to reach for it in 19 days. 3 of the 4, the grandfather, the father, and now the grandmother. Only the mother, Elizabeth, the 33-year-old at the center of so much of this, has not raised competency. And that absence, in a case where 3 co-defendants have, is starting to say something of its own. Sit with that asymmetry for a moment, because it is genuinely strange. Elizabeth is the youngest of the 4 adults. She is the one who gave birth to all 16 children. She is the one whose own attorney has said publicly that he is not certain whether she is a defendant or a victim, the one married at 15, the one who cowered in the booking video, the one with the unexplained bruise. If any defendant had an obvious path to a diminished capacity or coercion argument, on paper it might be her. And yet she is the only one not reaching for competency. Her defense has instead pointed at bond and at reunification with her children. There are two readings of that, and both are worth holding. The first is that Elizabeth is simply competent, that whatever happened to her, she understands these proceedings and can assist her lawyer, and her defense knows it. The second is strategic. A competency claim can slow a case, but it also concedes something, and a defendant hoping to be seen as a victim rather than a perpetrator may not want to open the door to being declared unfit. We do not know which it is, but in a case where the two grandparents and the father are all pointed at the same procedural exit, the mother walking a different road is not nothing. It may be the first visible sign that these four defenses are no longer one defense. And that silence is worth sitting with before we go on, because in a case like this, what a defendant does not do can be as telling as what she does. Elizabeth Siders is 33. She gave birth to all 16 of these children, beginning when she was 15 years old. She has no criminal record. On the booking video, she was the only one of the four not handcuffed, and by multiple accounts, she has been the most cooperative of the defendants since her arrest. Her lawyer, Thomas Stolley, has spent weeks building a very different kind of defense than a competency claim. A defense that says his client is not a monster, but a person crushed by extreme poverty. A woman who was herself effectively a child bride, who may be as much a victim of this household as an author of it. That is a coherent strategy, and it is the opposite of a competency strategy. A competency motion says, my client's mind cannot meaningfully engage with this trial. Stolley's approach says, my client understands exactly what is happening, wants to be reunited with her children, and has a story the jury needs to hear. You cannot easily run both at once. To argue someone is too impaired to stand trial, and simultaneously that she is a sympathetic, comprehending mother fighting to get her kids back, is to argue against yourself. So Elizabeth's absence from the competency column may not be an oversight. It may be a choice, a bet that her best path out is not through a psychiatric evaluation, but through the jury's sympathy. 3 of her co-defendants are reaching for the exit marked, not fit to proceed. She appears to be walking toward the one marked, let me explain. Which of those is the smarter bet is something we will not know for months. But they are visibly different bets, made by people who shared the same house and are now, one by one, choosing different doors. If you've been with this case, this is the moment I ask for the one thing that keeps this coverage going. What you are watching right now, the parsing of 3 competency motions, the difference between sanity and fitness, the slow procedural machinery that decides whether a trial can even happen. This is the part almost every channel skips, because it doesn't trend. This channel does it because it is where the truth of this case actually lives now. Subscribing is how you keep it in your feed, one tap. Then stay with me, because Christina's second motion is where this gets genuinely revealing. Because on the same day she asked whether she was competent to stand trial, Christina Siders also asked to be let out of jail. And the argument her lawyer made is the first real defense any of these 4 adults has offered, and it points unmistakably at the people beside her. The bond motion asks the court to release her on her own recognizance. The grounds are familiar in form. She is indigent, she has no prior criminal record, she is willing to wear a GPS monitor. But then the motion goes somewhere none of the others have gone. It states that Christina had long been providing for all of the other adults, and all of the children, that she was the one paying the rent, paying the utilities, keeping the household's lights on. It describes documented medical diagnoses tied to her own mental condition. And then it makes the argument that matters most, that there is no evidence Christina participated in any acts of abuse causing serious physical harm to these children. Read that sentence again, because it is doing something specific. The charge these 4 face, endangering children, in its most serious form, alleges abuse that resulted in serious physical harm. Christina's motion is drawing a line between 2 very different things, the active infliction of harm and the failure to prevent it. Her lawyer is effectively saying, whatever happened in that house, my client did not do it with her hands. She kept the utilities on. She was The motion implies closer to a bystander than an abuser. It is a legally shrewd argument. And it is also, whether her lawyer intends it or not, the sound of a defense beginning to fracture. Because if Christina's position is that she paid the bills and harmed no one, then the unspoken other half of that sentence is, someone else in that house did. In a case with 4 co-defendants and 1 shared roof, the moment one defendant starts distinguishing herself from the others, the shared front cracks. Prosecutors watch for exactly this. It is often the first sign that a group of co-defendants is about to stop protecting each other and start protecting themselves. One more detail from Christina's filing deserves attention, because it quietly resolves something this channel has been flagging as an open question for 5 episodes. For weeks, the origin of the June 30th search has been murky. Was it a sealed felony investigation? Was it connected to Gary Jr.'s indecency case? Reporting conflicted, the warrant was sealed, and we told you honestly that we did not know. Christina's own motion now states it plainly. Law enforcement came to that home on June 30th to serve another member of the household with an arrest warrant for unrelated misdemeanor charges. That is Gary Jr.'s public indecency warrant. Deputies came to serve it, and what they found inside led to a second warrant and to 16 children being carried out. So the thing that cracked this case open was not a grand investigation into the children. It was a misdemeanor warrant for 1 man. The children were found by accident. That detail has been circling for weeks. It is now stated in a defendant's own court filing. Which brings us to the misdemeanor itself, because it has a court date, and that date matters. Gary Siders Jr. faces 4 counts of public indecency, 4 separate alleged incidents at the Omer Street home between May 23rd and May 31st, and there is a detail in the complaint that reframes those charges. The person he is accused of exposing himself to was not a family member. Someone outside that household was close enough, on 4 occasions in a single week, to witness and report this. Which raises the same haunting question this whole case keeps raising. People were near enough to see that, and still no one saw 16 children. That indecency case has now been continued to August 13th. And Bober, along with other legal analysts, pointed to a likely reason the defense wanted it pushed. You do not let your client resolve a sex-related offense, plead to it, be convicted of it, while far more serious charges may be forming out of the same investigation. A conviction now becomes a fact a future jury could hear. So the defense freezes the small case and waits to see the shape of the big one. It is the same instinct driving the competency motions. Slow everything down until the full scope of the danger is visible. And the full scope is still not visible, which is the quiet scandal underneath this entire episode. More than 4 weeks after 16 children were carried out of that house, this case has not been indicted. Anjanette Levy, who has covered it more closely than anyone, confirmed this week. There has been no indictment, no new charges. The 4 adults are still charged only by complaint, 16 counts of child endangering each, a number that was actually reduced from the 17 counts filed at their arrest. The grand jury that will decide the real charges has not yet convened. And when it does, in a county that seats 1 only every several weeks, it may hand up something far heavier than what stands now, or it may need a special grand jury seated for this case alone. Meanwhile, the machinery that is supposed to inform the public keeps narrowing. A second gag order was signed on July 23rd, this one in Christina's case. Less restrictive than the sweeping order in Gary Jr.'s case, the one the Columbus Dispatch is still challenging at the Supreme Court of Ohio. As of this recording, that court has not ruled. Gary Sr.'s competency evaluation, ordered nearly 3 weeks ago, has produced no public result. Elizabeth's motion to reduce her bond sits unruled. Christina's 2 new motions sit unruled. The case is, in almost every direction you look, waiting. And competency is the deepest reason it is waiting. So let's follow that thread all the way down. Because most people assume an incompetency finding ends a case. It usually does not. Here is what actually happens. If the court orders an evaluation, a forensic examiner, a psychologist or psychiatrist, assesses the defendant against those 2 prongs and reports back. If the defendant is found competent, the case simply proceeds. If the defendant is found incompetent, the case stops where it is. But it does not vanish. In most cases, the court orders what is called restoration, an effort, often at a state psychiatric facility, to restore the person to competency. Treatment, medication, education about the court process itself. Many defendants found incompetent are restored within months and then stand trial normally. Incompetency is usually a pause, not an escape. Usually, but not always, and this is where the age and condition of these particular defendants matters enormously. Restoration assumes a mind that can be restored. For a 73-year-old man whose lawyer is comparing his decline to dementia, the honest medical question is whether his condition is something that improves with treatment or something that only moves in one direction. Dementia does not restore. If Gary Sr. is found incompetent because of a progressive, degenerative condition, there may be no treatment that brings him back to competency, and a defendant who cannot be restored cannot, under the Constitution, be tried indefinitely. His case could effectively end, not in an acquittal, not in a conviction, but in a permanent suspension. That is the possibility now sitting under this case like a fault line. One of these 4 defendants may never be tried because he cannot be made well enough to try. And the state has to prepare for a version of this case where one, or possibly more, of the accused is removed from it not by a verdict, but by a diagnosis. There is a constitutional principle underneath this, and it is worth understanding because it explains why the state cannot simply hold an incompetent defendant forever and wait. The law does not allow a person to be detained indefinitely solely because they are incompetent to stand trial. If there is no substantial probability that a defendant can be restored to competency in the foreseeable future, the state must eventually either begin civil commitment proceedings, a separate track, aimed at treatment and public safety rather than punishment, or release them. That is the fork a degenerative diagnosis creates. A frail, declining defendant who cannot be restored does not get tried, and does not simply sit in a cell forever either. The criminal case against him can quietly wind down into a civil, medical process that looks nothing like the reckoning the public expects. Now multiply that by 3. If the 2 grandparents and the father are all found to have genuine competency issues, this case could splinter into 3 separate procedural timelines, each moving at the speed of a different mind. One restorable in months, one declining and unrestorable, one contested for a year. And through all of it, the mother's case and the children's futures keep moving on their own clock. A single crime scene, 4 defendants, and potentially 4 completely different endings, none of them arriving at the same time, some of them perhaps never arriving at a jury at all. I want to be precise about what we do not know, because this is the part the exploitation channels are getting wrong this week. We do not know the result of any competency evaluation, because none has been reported. We do not know what is in Gary Jr.'s sealed motion, because it is sealed. We do not know Christina's specific diagnoses, because a filing that references them does not disclose them. Anyone telling you this week that these defendants have been declared incompetent, or that an indictment has come down, or that specific new charges have been filed, is inventing it. Levy confirmed there is no indictment, and there is no public evaluation result. This case is generating enough real drama that no one needs to manufacture more. So here, as of this recording, is the honest ledger. What is true? 3 of the 4 defendants have now raised competency. Gary Sr., by court order on July 9th. Gary Jr., via a July 24th motion he is seeking to file under seal. And Christina, via a motion filed July 28th. Christina also filed the same day for release on her own recognizance, arguing she paid the household's rent and utilities and did not participate in acts of abuse causing serious physical harm. Her filing states the June 30th entry was to serve a household member's misdemeanor arrest warrant. Gary Jr.'s 4 indecency counts, involving a non-family member, are continued to August 13th. The case has not been indicted. The charges remain 16 counts each, reduced from 17. A second gag order was signed July 23rd. The Ohio Supreme Court has not ruled on the challenge to the first. All 4 defendants are presumed innocent. What is theory? Whether any of these competency motions will succeed, whether they are sincere, strategic, or both, whether Gary Sr. can be restored to competency if he is found to lack it, what Christina's fracturing defense signals for the others, and what a grand jury will ultimately charge. What is invention? Any claim that a defendant has been found incompetent, no result exists yet. Any claim of a new indictment or specific new charges, Levy has confirmed there are none. The contents of Gary Jr.'s sealed motion, and the usual sludge circulating on channels that would rather guess loudly than report carefully. If you suspect a child in your community is being neglected or abused, Ohio's hotline is 1-855-OH-CHILD, 1-855-642-4453. You do not need proof. You do not need certainty. Reasonable suspicion is the whole threshold, and trained people take it from there. One last thing before you go. There is a bitter symmetry to where this case has landed. For years, the central failure around this family was that no one with authority looked closely enough. Not the schools they left, not the counties they moved through, not the systems that saw them and moved on. The whole tragedy was a failure of scrutiny. And now, at the end of it, everything hangs on scrutiny of a different kind. 3 forensic examinations, peering into the minds of 3 aging defendants, to answer a question the law insists on before it will let a trial happen. Can these people even understand what they are accused of doing? There is something almost unbearable in that. The 16 children spent years being not seen, and the adults who are supposed to answer for that may spend the next several months being examined more carefully than anyone ever examined those kids. Whether that examination ends in a trial, in a hospital, or in a case that quietly stalls out, it will not happen quickly, and it will not happen loudly. It will happen in sealed motions and evaluation reports and hearings that barely make the news. This channel will be there for all of it, not for the outrage, but for the follow-through, for the competency rulings nobody clips, for the grand jury when it finally sits, for the moment someone unseals the pages that explain how this ends. If you want to be there when the answer comes, subscribe and stay. 16 children were found in one room. The people accused of putting them there may never see a jury. And the reason why is now the whole case. I'll see you on the next one.